Good afternoon, folks. My name is Mustapha Ndanusa. I'm one of the partners at Davis Ndanusa, Ikhlas, and Salim. We are a general litigation firm where we practice immigration, criminal defense, landlord-tenant, and even just general litigation types of cases. Today, I want to talk to you about landlord-tenant court, which I've been practicing for since 2001. And I want to discuss more specifically the impact of COVID-19 on landlord-tenant litigation. So as many people would know, in March of 2020, the governor issued an executive order that pretty much declared a state of emergency. And then by March 18th of this year, the governor then modified that order such that the state of emergency became that only essential workers could be out and about and out of their homes, and everybody else is, for the most part, been quarantined until most recently when we have seen a relaxation of the executive order. So that executive order has impacted landlord-tenant, has impacted all types of litigation dramatically. But again, today I just want to focus mostly on landlord-tenant. I want to go over about 10 different items of how we believe a landlord-tenant has been affected by COVID-19 and by the different executive orders and the different administrative orders from the different judges and the different courts. First is the commencement of actions. Until very recently, well, still hasn't happened yet, but you cannot commence a landlord-tenant action. You cannot commence a holdover, you cannot commence a non-payment. For those that don't know, very quickly, a non-payment is just like it sounds. It's where you believe that the tenant has breached the condition of the lease and the tenant has not paid rent, and therefore you want to take the tenant to court to collect rent. A holdover usually are cases where there is no lease. This is very critical because in a non-payment, you have to have a lease, because a lease then tells the court what it is or what amount of rent is in dispute. A holdover typically, as I said, does not include a lease. So you are essentially arguing that you don't want the person there anymore because the person doesn't have a lease. Now, of course, if this is a stabilized apartment, that's a whole different area that I'm not going to get into right now. But whether or not you have a holdover or you have a non-payment action, you cannot commence either one of those actions until June 22nd, 2020. Today is June 15th, 2020. So if you're listening to this video sometime after June 22nd, some of the information that's here may become irrelevant or moot. The second issue I want to talk about is evictions. So right now you cannot evict anyone, at least not until August 20th of 2020. There's been a moratorium on evictions. The only exception to that is going to be something that I will talk about later on as I continue my discussion. The third item on our list is security deposits. What I mean by that is if you have a security deposit that the landlord is holding for you, which is the case for most tenants, when you move into your apartment, the landlord is going to ask for 1 month security or 2 month security, whatever the case might be. Although now, as of June 15th, this is not necessarily one of the topics I wanted to discuss, but just so people know, as of June 15th of 2019, a landlord is only entitled to 1 month security deposit and no more than that. So let's assume that this was even before June 15th, you had a security deposit of 2 months, 3 months, however much it is that you put down with your landlord. And because of COVID-19, you have been impacted financially and are unable to pay your rent. With your permission, the landlord can apply your security deposit to the rent arrears. However, once the landlord does that, so that now it's June 15th, let's just say for July 1st, the landlord decides to apply your $1,200 security deposit to the $1,200 that you are in arrears. Once the landlord does that with the tenant's permission, then the tenant has to replenish that security deposit. The tenant has 1 year pretty much to do that. You are obliged to apply the security deposit on a 12-part system. So you basically get 12 months to give the landlord $100 each month until the security deposit is paid in full. The next item from the executive order is an obligatory relief. Now, what that really means, a lot of lawyers still don't know what that means, but according to the executive order, suggests that if a tenant comes to a landlord and says, I need some type of relief with rent, more than likely it's going to be something dealing with rent, because I've been impacted by COVID-19. I lost my job, or whatever the case might be. Maybe there was a reduction in my job, and so I'm not getting paid as much, and I can't afford this apartment. According to the executive order, the landlord is obliged to offer some type of relief to that tenant. Exactly how much relief, that's unknown. Exactly what documents the tenant has to provide to the landlord so that the landlord is satisfied that the landlord can give the relief, we still don't know. Again, what type of relief, how much relief, we really don't know, but there's some kind of obligation to give the tenant or offer the tenant some type of relief. We suggest that you talk to your attorney before engaging in that conversation with your tenant. And if you are a tenant yourself, we also suggest that you probably speak to an attorney when you're going to engage your landlord in that type of conversation. And in terms of the relief itself, one of the two criteria is that the tenant has to be able to demonstrate that they were impacted, he or she was impacted by COVID-19, and also that the tenant was eligible for unemployment insurance. If they meet those two requirements at the very sort of basic level, you have to entertain the person's request. The next item, number 5, is late fees. Now, what I mean by late fees is that from March 20th until August 20th, pretty much, you cannot charge late fees to a tenant because the tenant did not pay their rent in a timely fashion. That's also according to the executive order that you're not allowed to charge the late fees, ask for the late fees. Now, going back, remember I mentioned June 19th, that was the HSTPA, the Housing Stability and Tenant Protection Act that came into effect in June 15th of 2019. According to that particular law also, if you go to court, if your landlord takes you to court, that landlord cannot evict you simply because late fees are owed. So for example, you go to court, the landlord has sued you for 2 months of rent, $1,200 a month, $2,400 is going to be owed. But then the landlord is also charging you $50 in late fees. But you have all $2,400 to pay the landlord and to make the landlord whole. But the landlord wants the extra $50, and if you don't pay the $50, then you will be evicted. That is no longer the case. The landlord is not entitled to the late fees as a basis for evicting a tenant in landlord-tenant court. So the next item is motions and settlements. Motions, settlements are always encouraged in any circumstance. They're even more encouraged in this particular circumstance that we are finding ourselves in with the advent of COVID-19. If you have 2 attorneys, even if you don't have 2 attorneys, but if you have 2 attorneys more specifically, this is what the courts are encouraging. If you have 2 attorneys, the attorneys are being encouraged to ask for a conference. Before, you have to have a consent of both attorneys to ask for a conference. But now any attorney can ask the court for a conference, and you can have a conference with settlement. And the courts are really looking forward to this because the courts have been backlogged, and we will continue to see a backlog of cases as we proceed in the future. So you can either ask for a conference, so you can have a settlement, or any other discussion that you feel is relevant. And also, you can make a motion where you weren't able to make motions before. You can make motions. If you file the motion and the motion has not been responded to, you can oppose the motion, or you can just go ahead and file a new motion through the EDDS system, which I'm not going to get into. It's a database, pretty much, or that allows you to be able to file motions and to file certain documents online for cases that are not already part of the e-filing system. Also, you can file appeals now, or you can file at least a notice of appeal. If you already had an appeal pending, the appellate court was moving forward pretty much, although a little bit slowly compared to their normal pace, the appellate courts are pretty much moving. But landlord-tenant court for a long time had come to a standstill. Supreme Court came to a standstill. Civil courts, the lower courts came to a standstill. But now, if you have a case that's already been decided, and because there was a statute of limitations moratorium, and you weren't able to file your notice of appeal, you can now go ahead and file your notice of appeal if you feel that you have been wronged by a lower court. The next item is not something that has come through the executive order or an administrative order, but it's also a little important to sort of note that the City Council is working presently on a bill that, if passed, the bill will put a stay on sheriffs and marshals from evictions. For how long, we still don't know, and also from collecting debt. So if, for example, you are a tenant and there was a non-payment action, or even a holdover action where a monetary judgment was given against you, or even just a civil case where there's a monetary judgment against you. If this bill is passed as it has been proposed, then the marshal or the sheriff will be prevented from going after you for that particular judgment until such a time that the bill states that that particular stay will be lifted. The next item, number 9, is a motion to evict. As I mentioned before, there is a moratorium on evictions. However, if you were able to get a warrant of eviction prior to March 20th of 2020, you can make a motion to the court for permission to move forward with the eviction. Now, can you still evict? Doesn't look like you'll be able to evict until August, but I guess to the extent that when August comes around and you just want to be able to move forward really quickly, you can make the motion to move forward with the eviction, but there are 2 requirements, or there may be 1 requirement that encompasses 2 things. The requirement is you have to have an affidavit from a person with personal knowledge, which is probably going to be the landlord. How much personal knowledge the landlord has, as you'll see, based on what the landlord has to attest to, that's going to be difficult. However, what the landlord has to be able to do is demonstrate to the court that 1, the tenant that you're seeking to evict has not been impacted by COVID, and 2, that the tenant is not someone that would otherwise be eligible for unemployment insurance. That may be a very tough task for the landlord to be able to demonstrate, but if the landlord is able to demonstrate that, the landlord will then be able to move forward with the eviction. Now, finally, I want to talk about things that are just off the presses. Literally, just had a conference with one of the administrative judges in Landlord Tenant Court, and these are some of the new things that we have come to learn. One, as I already mentioned, is that June 22nd, which is the next Monday, today's the 15th, the next Monday, the courts are going to be open for people to actually literally walk into courts. Now, New York City is still in phase 1 of the reopening. Other parts of the state are already in phase 2. They're probably going to phase 3 already. That all depends on what the governor has determined, whether or not we've hit certain benchmarks to be able to reopen completely. But we are still in phase 1. And as part of this phase 1, the court judges are already in their chambers. Part of the court staff is already there. The clerks, some of them are there. They're about 20% now is what I'm learning. However, you can go and file a new case starting June 22nd. You have to stand in line. The lines are probably going to be long. There's only going to be a limited amount of people that are going to be able to go upstairs on the 2nd floor or 3rd floor, depending on which county you're in, to be able to file the case in front of a clerk. As I said, there aren't that many clerks in the courthouse. So just be aware and anticipate that there are going to be long lines if you are going to file any new cases. The next thing that we learned is that if you live in like a NYCHA building or some other building that is receiving government funding through the CARES Act, then those buildings are one of the few exceptions to this particular rule about commencing cases. If you're going to commence a case against someone that lives in NYCHA or other kind of government-funded programmed housing, then you're not going to be able to start a new case against those particular tenants. Next thing that we learned is if you have been served with a case and you want to answer, the answers are going to be done telephonically. The courts are going to be able to provide people with information on how they can call, what numbers basically they can call so they can file the answer telephonically. All appearances also are going to be done virtually. The court is going to be working on trying to have some kind of system inside the court that litigants can come to, especially pro se litigants can come to. They can go to a portal and be able to maybe use that portal to then be able to have a virtual conference with the court. So all appearances are going to be virtual. We're not going to be having anyone in court, at least not in the first phase, probably not even in the second phase either. Adjournments are going to be prolonged. They're going to be very long adjournments. So if you have a case that has started, if you commence a case, usually on that very first court date, the case is going to be adjourned. If it's adjourned, it's going to be adjourned to sometime into phase 2. When phase 2 is going to start, we don't know. phase one started, at least as of June 10th of 2020, we were already in phase one. Typically, we're looking for about 2 weeks or 3 weeks before going to the next phase. When exactly phase two is going to start, we don't know, but definitely the word on the street is that cases are going to be adjourned into phase two. If you are someone that is eligible for counsel, so universal access to counsel, and you are then given that counsel, what is going to happen is your lawyer is going to appear for you by either by telephone or by some type of remote virtual access. And that lawyer is going to ask for time, and the courts have said that they're going to give them time, because what is going to happen is typically under normal circumstances, instead of the sort of new normal that we are living under today, under normal circumstances, the counsel would have been able to meet with the tenant, be able to discuss the case. That's unlikely to happen. So the counsel is going to be granted an adjournment pretty much automatically, which is something that was probably going to happen anyway. But it's going to be for a different basis. It's not going to be just asking for an adjournment. It's simply to accommodate the counsel that has more than likely not had an opportunity to speak with his or her client. And as I mentioned before, existing cases where there are two attorneys on the cases, those cases are going to be taken first. Trials are not going to be happening. The courts are not fond of virtual trials. It doesn't look like courts are going to be doing virtual trials. What it looks like now is that we're going to wait until phase 3, which is going to be probably more of the reopening of the courts, more staff is going to be available, more people are going to be allowed into the courthouses themselves, and it's only at that point that it looks like we're going to have trials continuing, if you have a trial already or if you're going to be scheduled for a trial. When phase 3 is going to happen, we still do not know. The next item for this latest news that we received is that there will be no defaults. So if you are a litigant, you've been served with papers, you fail to appear on the date that the court says you're supposed to appear, and the appearance is going to direct you as to how you're supposed to appear, whether it's by telephone or virtually. If you fail to appear, courts are not granting defaults. If you have a warrant and your warrant was gotten prior to March 20th of 2020, and it was gotten through default, courts are not going to acknowledge those warrants either, because more than likely probably have to do it over anyway, because there's something called a non-military affidavit, and that's going to become stale. You have to do a new one, so you have to do the whole thing over. So again, there are going to be no defaults. And as I mentioned before, if you have an eviction, a notice of, sorry, not a notice, but a warrant of eviction prior to March 20th, they want to move forward with that, you do, but you do not have to make a motion if your case is a holdover. So those are just a few of the things that we have learned most recently, and I've already talked about how COVID-19 and the executive orders and the administrative orders have impacted landlord-tenant litigation. So starting June 22nd of 2020, that's going to be sort of the first phase of the commencement of actions and moving forward with landlord-tenant litigation. What we have been suggesting to our clients, we represent both tenants and landlords. What we have been recommended to them is that you should have already started talking to your tenant. If it's a non-payment, discuss with your tenant. How can the tenant make you partially whole? If you're a tenant, how can you make the landlord partially whole so that you don't even have to go to court? Or if you go to, even if you have to go to court, at least some of that relationship has already been mended. You've already been in conversation, so it's not going to be an acrimonious sort of relationship in court. So that's what we have been suggesting to many of our clients to already start thinking about. So if you found this information to have been helpful, if you found it to have been informative, we hope that you'll be able to spread this to your friends, loved ones, anyone that you believe might find this information also helpful. And finally, this is just information. It's not consultation. I'm not giving you any advice. If you need advice, every case is different. If you need consultation, then you need to speak to an attorney about your individual specific case. So I thank you again. My name is Mustapha Ndanusa, and I'm one of the partners at Davis, Ndanusa, Ikhlas, and Salim. Take care.